Hi, my name is Ryan, a partner at firmTRAK Solutions. I'm joined today by Carin and Rich, our other two partners. How are you guys doing today?
Good, how are you?
Happy to be here.
So we saw recently that the ABA, the American Bar Association, has released their formal opinion 512 about the use of artificial intelligence or generative artificial intelligence. We just wanted to take a moment, since we do a lot of work with attorneys, and Rich, one of our founding partners, is a practicing attorney, just go through the bullet points and kind of give a brief overview of what the opinion says on generative AI. So a couple of the bullet points beginning out, the first one here we have is competence. Lawyers using generative AI must understand the technology's benefits and limitations. They should ensure that their associates have adequate training and a knowledge of the GAI tools used them competently. So, for example, if a lawyer uses a tool to draft a contract, they can't solely rely on the AI output. They have to review it for competency and output, and they can't do that without verification.
Yeah, so from a practicing attorney standpoint, I utilize quite a bit of artificial intelligence to help me maybe get started with some things and understand documents, and utilization of the tool can save a significant amount of time. But I think that there are two components that the ABA opinion hits on that I think are very important. The first is we have to understand the limitations of the tools that we're using, and the acceleration of the advancement of the technology is exponential at this point. So the capabilities of the current AI are tenfold what they were even probably a year ago or 6 months ago, and we expect and anticipate that's going to continue to happen. So the first part of the competency that the opinion touches upon is your ability to be competent on the technology that you're actually using, and I think that's very important. You need to understand the limitations. The second part of competency, which I think is required with generative AI, is that as attorneys we have the ability to understand and apply law, facts, to come up with some sort of a result or a final product for the client. Using generative AI can assist with that function, but it cannot be the only determining factor on how the product is complete. For generative AI to work, you need to have somebody who can understand what the AI is doing and then be able to correct it or make any changes that are necessary. The concept of just throwing questions into a generative AI bot and then taking the response and sending that to a client is what the ABA talks about as being particularly problematic, because the people that are utilizing the technology do not have the skill set to understand what the generative AI is actually doing. So I think that's a huge part of the competency issue raised in this opinion.
And then the second bullet point we have here from the ABA is confidentiality. Under the model rule 1.6, lawyers must protect their client information when using GAI tools. And this one kind of extends beyond the attorney practice and also bleeds over into the accounting practice. Because depending on the type of AI tool you're using, if you're uploading your client data with specific names and confidential information, the tool is learning off that data depending on what price model you're using. For ChatGPT, you pay the sub fees, they don't keep your data. If you don't pay the sub fees, they're using your data to improve the AI. So you really want to be cognizant of what you're using with client data and confidentiality. And then the other point I wanted to make on that is, in the opinion 512 from the ABA, they stress that if you have enough attorneys that you have ethical walls between your attorneys for certain matters, and that's all in the GAI tool that the entire office is using, you better be cognizant and aware that one attorney may have access to data they shouldn't have based on the ethical wall they need to be building for confidential client data inside their own firm. The third bullet point we have here is communication. Lawyers must disclose GAI usage to clients if it affects their decisions, required by client guidelines, and it just wants you to be transparent about AI use, and they recommend to put that in your engagement letter. So, for example, if a significant portion of the research is used, and it affects the output of the work product, you may want to consider advising the client on how that decisions are being made.
Well, one of the real-world applications of the notification regarding the use of AI would just be a slight modification of your engagement letter. Put a small paragraph, 2 or 3 sentences indicating that generative AI may be used in the services that are provided, and at that point you've made the disclosure that that's something that you may utilize in the course of the representation.
Yep, and then just the last couple points here are the supervisory responsibilities. Law firms should establish their policies on the ethical use of GAI and ensure all staff and contractors are trained appropriately to use the artificial intelligence. And you may have one thing to consider is all your contractors that you bring on board and any of your policies and procedures, and have a formal process in place to train contractors that may or may not otherwise be included in that, like your employees are. And then lastly, the fees. Any GAI related expenses billed to clients must be reasonable and aligned with Model Rule 1.5. Time saved through AI should not be overbilled, and client consent is advised for specific GAI fees. So, Carin, did you have any?
Yeah, I found that to be, there's a specific part of that particular bullet point that I found to be somewhat ambiguous. And I think it's very important for attorneys and even accountants to stay extremely cognizant of what's fair. So for instance, if a lawyer is using a GAI tool to draft a pleading and expands 15 minutes on it, and the input the relevant information into the program, the lawyer may charge the 15 minutes as well as for time the lawyer spends to review the results of the draft for accuracy and completeness. As further explained in their opinion 93-379, if a lawyer has agreed to charge the client on an hourly rate basis, and it turns out that the lawyer is particularly efficient, then in accomplishing a given task, it nonetheless will not be permissible to charge the client for more hours than were actually spent on the matter, because the client should only be charged a reasonable fee for the legal services performed. The goal should be solely to compensate the lawyer fully for time reasonably expended, an approach that, if followed, will not take advantage of the client. And I find that whole opinion to be very ambiguous.
Well, I mean, from my perspective as an attorney who utilizes some of the tools, the reasonable nature of the expenditure isn't directly related to the amount of time I believe that you're using the AI.
Right.
I mean, it's just the benefit of the AI in savings of some time is something that would be carried over to the client. But even the utilization of the tool still requires the review, the finish, the finalization, the implementation and clarification of various legal issues and facts. The AI can help you kind of get there, but it's not necessarily delivering the final product. So I think the reasonable reference that's contained in the opinion, as Carin pointed out, is it's not a minute for minute timeline so long as you're on the technology. It just has to be reasonable after you include all of the other items that need to be completed in order to perform the task or complete the deliverable that you're working on. That's kind of how I read it anyway.
I wish it was just a little more specific.
Wow.
All these opinions that are issued formally by the governing bodies, accounting, legal, and nonprofits, etc., they're going to be changing rapidly over the course of the next however many years AI is with us. So it'll be interesting to say the least. So I'm Ryan, partner at firmTRAK Solutions. This is Carin and Richard, also partners at firmTRAK Solutions. Come and see us at our website, firmTRAK.com, and let us know if you want to have any further discussion about AI or anything else.